Um, what is at risk if we don't do any estate planning. And I don't know why this is showing my full screen, but anyways, so sorry if you get a little bit of repetition, but I will be elaborating a lot more in the areas of estate planning for parents of minor children, and hopefully that will be worth it. The contents of this presentation, as well as any answers discussed during the Q&A, are provided as general legal information only, and please don't take it as legal advice. For help with specific legal stuff, you should consult with a licensed attorney. Okay, and all right, here we go. All right, so I'm Leslie Sultan. I'm an estate planning attorney. I've been working, I have 2 children, ages 6 and 8. They just started 1st and 3rd grade. And I'm also a business owner. I founded my business in 2010. And we, try to take a very personal approach with all of our cases. So that's a little bit about me, in addition to what Annette had originally told you guys. Okay, so probate. I like to start there because I want to make sure people understand, what happens if we don't do estate planning. So, sorry, somehow this skipped one. Oh my gosh. Okay, let's see if this works now. Okay, I guess not. So probate is the legal process for what happens when someone dies with or without a will. The most important thing to know is that probate does take a long time. If you're in New York, I'm in New York. I'm also licensed in New Jersey. So it does depend on what state you're in, how long it could take. For example, New Jersey's relatively quick. New York, California are very long. Queens, for example, Queens County it's about 6 months. So that means from the date of filing to when you actually can do anything for the estate, it's about 6 months. In some cases like Brooklyn, it's way longer. And there's costs involved. So you're going to have to pay, families most likely are going to pay attorney's fees. There's court fees. Attorneys charge an hourly rate. We charge $4.50 an hour for probate. Costs can easily exceed $10,000 just to get access to the deceased person's estate. And then, for example, we've seen cases where the family cannot afford an attorney because they don't have access to the deceased person's funds. And now they're working out an agreement with the attorney for a percentage of the estate. So, for example, if an attorney took 5% of $1 million estate, that's $50,000 going to the attorney and no longer to the family. So you definitely want to try to avoid probate if possible. To just avoid that cost. So some people think, if I have a will, can I avoid probate? No, a will has to be probated. If you don't have a will, which we all start out with no will, the state has a plan for you. So the first thing you want to know is, what is the plan in your state? So in New York, for example, as a mother, I'm not married, I have 2 children, everything goes to my children in the state of New York if I don't have a will. If I have no children, but I have a spouse, it goes to the spouse. If I have both, it's divided. If I have only my parents alive, then it goes to my parents. So there's a whole hierarchy, and that's the plan. So if you don't like that plan, you have to do a will to change it. It also gets complicated with filing. If you don't have a will, there's no lapsing. So grandchildren can inherit, even though you would have wanted something to go to your children. There's a bond that has to be paid in order for the court to allow somebody to step up and get access to the funds. And the biggest thing is, again, nobody can access the funds for the deceased person until letters are issued by the court approving that person. And so that's, can take a while. And then, of course, the question, if I have a will, can I avoid probate? No. And the answer is, a will has to be verified. So you can't take the will to the bank and be like, give me my money. The bank is going to say, we have no way to verify that. We need a judge to verify it. So again, during that time, everything's basically frozen. If you're a homeowner, you can't, and collecting rents, you can't collect rents during that time. It's going to be hard to pay the mortgage. The family would be paying for things to maintain the assets and then be able to seek reimbursement later. But the ultimate outcome is that it wastes the assets because 6 months of expenses and no income can really hurt the assets of the administrator, of the deceased person. So that's sort of the short version of that. I see there's something in the chat. I just want to check if that was a question about anything. Okay, no. All right, so how can I avoid probate? So this is the biggest thing we want to talk about for families with minor children, is creating a trust. This is important for a lot of reasons, but the basics I want to explain is a trust. Basically, you would transfer all of your assets into the trust, and then you can still maintain control of all those assets just as if they're in your name while you're alive. And then the transfer of the assets happens automatically once you pass away or become incapacitated. There's no need for court, there's no need for probate, no need for any judges or lawyers to get involved. It's an automatic transfer. And the new trustee can automatically take over. They don't need authority from anybody. So the analogy I like to use is a purse. So I can, and that's why I named my podcast The Legacy Purse. So if you have your purse, you put all of your stuff in it, your checkbook, your wallet, your house title, everything's in that purse. You're still in control of it while you're alive. And the minute you pass away, they just take that purse, give it to the next person, your successor trustee. And now they are in control of the purse and everything in it. Okay. I'm trying to switch slides here. It's like too hot. Everything's melting. Okay, so we defined a trust. So defining a trust is basically, it's something you create during your lifetime. It's basically a contract you create with yourself for the benefits of your children or family, to distribute your assets or manage them if you become incapacitated or pass away. Why this is really important. Also, in addition to estate doing a trust, estate planning, you want to do a will, because a will can name guardians for your children. And obviously, this is a really important thing for parents with minor children, because we don't want anybody applying for the court and raising our children, right? We want to have a say in who's going to raise those kids. So you want to put that on paper. I nominate my sister, and if she's not available, I nominate my friend. And if she's not available, I nominate this person. If you're not doing that nominations in your will, then anybody can apply for guardianship. You can have competing guardianship petitions by various family members. Another thing you can do with estate planning is an exclusion, guardian exclusion, to say, I do not want under any circumstance this person to raise my kid for the following reasons. And this document only becomes available, hopefully if you've done it right, during that court proceeding, and the judge will take that into consideration. So by doing the guardianship nominations, you're hopefully able to avoid a dispute. You're able to let the family know, hey, I'd like you to take over. These are how I'd like you to raise my children. It's just kind of about communicating and documenting what your wishes are. And I can also talk later about the difference between temporary guardians and long-term guardians if people want to know more about that. The other really important thing that most people don't realize is that minors cannot inherit. So anyone under 18, they can't receive a gift, an inheritance, even a life insurance payout. So what happens is parent passes away or somebody passes away, leaves money to a child. Another adult has to be appointed as guardian of the estate of the child, of guardian of the property. So again, we're back in court just dealing with the assets for the children. The other parent might be alive, they're raising the child, but that money coming to the children has to go through the court system. I have a case where grandma set up life insurance, and she named all the grandchildren as the beneficiaries on the life insurance. One of those grandchildren was 14. So mom had to pay an attorney to go to court and get authority to be the guardian of the child's money. And then the judge, of course, had her put it into like a very conservative, not growing interest savings account, because obviously the court's not going to allow any kind of, risk taking with the child's money. And then when the kid turned 18, he didn't automatically get the money. She had to petition the court to release it to the child. She said she spent $50,000 in legal fees on this. So that sucks. This could have been avoided by having set up a trust, have the life insurance pay the money to the trust, and then the trustee distribute it at a certain age. The other thing to think about as a parent, right, is do you want your child at 18 to receive potentially hundreds of thousands of dollars, right? Like if you've got that life insurance policy, $500,000 for a kid, that's at 18, right? So not everybody likes that idea. So with estate planning, you can set terms like, I want a portion of it to go out at age 25 or when they graduate college, and another portion when they get married. It's very flexible. You have all that kind of say. And so that's the beauty of doing estate planning, is you're able to say, like, I don't want my kid to get at 18, let them get a little bit of experience, real life, struggle, and then they can manage their money and their inheritance.
I have a question since you paused.
Go ahead.
What if it's the case where the parent or the person who's estate it is says that my grandchild or my child should get this money once they graduate college? What if they never graduate college?
Yeah, we do get that, and what we do, and then what is college, right? Is it a trade school? Is it dental school? So when I have a client come to me and do that, then we do kind of like work through those terms. So it's like, okay, well, what if they don't graduate college? They never get the money, or is there another age we can add, or which one comes first, something. So that's, it reminds me of another reason, like some people think, oh, I can just go online and do estate planning online. And it's like, yeah, but then you're not going to have somebody walking you through those decisions that you're documenting there to say, oh, okay, when they graduate college. So yeah. The other thing you can do is also name a child as co-trustee, so that they are also managing the money with another person. And that some people think that's a good way of helping them learn how to manage their inheritance. So yeah, there's a lot involved, obviously, but the best part about the estate planning is you can really have fun with it, and you can really feel like you're leaving your wealth and your legacy the way you want it, and see it done not just through the state's rules, but the way you'd like to do it if you were still alive. And some people, we can think about, another option is a sub-trust for the children for their lifetime. So they never actually get it. I mean, that's what the rich people do. They have, the trust fund babies. That's what this is, right? The money's in trust. It never goes outright to the child. The trustee's always managing it for them. And that could happen, what if the child has a drug or alcohol problem? I mean, they lost their parent at a young age. You never really know. So this allows the trustees, people that are trusted, to manage the money for them and not spend it in bad ways. Of course, with the subtrust, it's great. It can pay for all the things that they would need: health, education, maintenance, support. Those are the standards. And there's also ways to create subtrust for special needs children, which is really important and often overlooked. So I'm going to get into that real quick. So the main thing with special needs children is, they're usually receiving government benefits. So if they receive a big chunk of money, that's going to kick them out of their benefits. And depending on how severe the needs are, they might not be able to do anything with it, or they might not be able to manage it appropriately. So the idea is to set up what we call a supplemental or special needs trust. And that's where somebody manages the money for the lifetime for the child, with a little bit of restrictions around what can be done. But that way they're always, able to buy extra clothes, or, depending on the needs, enjoy their life without being disqualified from the benefits, and without, the inheritance being spent in ways that we wouldn't want them to. So I like to use celebrity stories as examples. So I'm going to go over these. Feel free to ask any questions along the way. I don't know where, well, I think this is an old slide. Robin Williams. Well, yeah, he didn't have minor children, so I'm going to skip him. Sorry, Robin. I like Whitney Houston, though. She's a great example. So Whitney Houston, as you know, was married to Bobby Brown. They had a child, Bobby Christina. Whitney Houston died. I'm sorry. They got divorced, Bobby and Whitney. If you've seen the documentary about her, or the movie about her, but you probably know this anyways. Okay, so divorced, drugs, blah, blah, blah. Whitney Houston dies. Whitney Houston did a will, and in her will, she set up a trust for her daughter, Bobby Christina. And it says at 18, Bobby Christina gets a third of the money, and the balance, another third at 25 and another third at 30 or 35. As many of you know, Bobby Christina died the same faithful death as her mother at age 20. So what does that mean? So what happened? Bobby Christina received a substantial sum of money at 18. She received 1/3 of her inheritance. Bobby Christina did not do estate planning, which is probably okay. I don't know. She was dating that weird guy who's accused of like killing her. So we don't know what she would have done with the money. But because Bobby Christina didn't do any estate planning, who do you think inherited that money? In the state of California, her only surviving heir was her father. So now Bobby Brown has received all of this money from Whitney Houston. Probably not what she wanted. Luckily, Whitney Houston did have those other clauses saying another portion goes out at 25 and the balance at 35. That way, a huge chunk of Whitney Houston's money was preserved and went to her sisters, because she said, if my daughter's not alive, I want it to go to my sisters. So that's the good news. She did do something similar to what I was explaining earlier, is set up that payment structure, and she was able to preserve her wealth. Otherwise, 100% of it would have gone to Bobby Brown, which would have been really tragic.
Leslie,
So
actually, I have a question.
yeah.
To your knowledge, do the laws that govern estate planning vary significantly from state to state or internationally?
Okay, so I don't know international. I mean, that's a huge world of estate planning, but I do know that they vary slightly within the states. They even vary, like New York's rules change over time. So for example, now, if I'm married and have children, the first $50,000 of my estate goes to my spouse, and then the balance is divided between my children and my spouse. That $50,000 used to be $4,000, so it changes over time. Every state kind of has something similar, but I don't know all of the states. I'm only licensed in New York and New Jersey. But you can easily Google this. I mean, you could do it while you're in line at the grocery store. What happens if I die in Tennessee without a will? It's the laws of intestacy, and it's really easy to find. So yeah, I always recommend start there. If what you see is something you like, that's fine. The next question is, what's the probate process in your state? So we have some states that are what I call probate friendly, like New Jersey, Connecticut. Those are very smooth, easy processes. But then there's other states, Florida, California, New York, that are it's just very difficult to get that and very slow.
We have just a comment here says, I have a trust, and at the last piece, which is I have a trust. I guess the last piece is to put the properties in the trust. I don't own the property since mortgage has not been paid off. What are the downsides of doing this? It is a big issue if I choose to refinance while this is in the trust.
Okay, so I really appreciate that question, because there's a huge misconception around trusts and mortgages. So it's going to depend on the type of trust that you have. If you have a revocable living trust where you are the trustee, there is law, it's called, I can't remember the name of it right now, that says that a bank cannot prevent you from moving that house into your trust. Okay, this is a different situation if you are not the trustee. Okay, so I don't know what your circumstances are. If it's an irrevocable trust or a trust controlled by somebody else, then the bank can deny it yeah. But you absolutely can, in New York, transfer your house into the trust if you are the borrower and you own the house and now you have a trust. Yeah, and that's really important, because if you took the time to set up a trust to protect your assets, a house is probably one of your largest assets, and you do need it to be in the trust for the trust to work. And then the trust pays the mortgage. I mean, it's not an issue. Generally speaking, in my opinion, or in my experience, the banks don't always know that the transfers even happened. But if you wanted to get consent from the bank, then you would just reach out to them. Unfortunately, probably the first person you talk to is going to tell you, no, you can't do that. So you have to escalate it to a supervisor or manager. Don't take no for an answer until you can get to the right source. But I own a house, I have a mortgage, and it is in my trust. So I do it all the time for clients. Yes, sometimes the broker will tell them, no, you can't do it, but ultimately, yes, you can. At least in New York. I don't remember if there was something else I was going to say. So yeah, so that's the trust. Oh, the purse analogy, right? So I talked about the trust as a purse. Yeah, it's really important that you fund the trust or put the stuff into the purse, right? Everything has to be owned by the trust. Whatever's not in that purse is not going to transfer. It's like, if it's still, you got stuff in your pockets, it's not in the trust, it has to go through probate. So if you've set up a trust, you have to fund it. You have to move your assets in there. The trust is a contract that legally controls only what it owns. So if it's not in there, it doesn't own it, it can't control it, it's going through the probate courts. So either go back to the attorney that set up your trust, or contact an attorney if you're having issues with your transfers. I'll just do Heath Ledger because that's another minor case. He died at 27, I think it was, and he had one child and a girlfriend. Heath Ledger did do a will. He did it before his baby was born, so before he met his girlfriend, apparently. So in his will, he had left everything to his parents, and then he never updated it after his child was born. So at 2 years old, when the child, the child died, he died, the child was 2 years old. She's not entitled to anything because he did a will that left everything to his parents. He left nothing, nothing was going to go to the girlfriend to raise the child. So this is another thing that when you do estate planning, you do want to periodically update it, or at least consult with someone about updating it to make sure these kind of things don't happen. So Heath Ledger did a will, go Heath Ledger, but he forgot to update it 2 years after he had a child. And the result is that he left the child and his girlfriend out. I don't think that was his intention. I think he just didn't get around to it. Luckily, his parents worked it out where they were going to give everything to the child, so it was resolved. But obviously, this is a lesson to learn why, we want to avoid these things. So that's basically my spiel on estate planning for parents of minor children. I'll definitely take questions. Here's my contact information if you wanted to reach out privately, but otherwise I'm happy to take questions and answer and hopefully give you guys more suggestions.
I have a question. So when you go, somebody comes to your office for a consultation and they, you set up this trust, is there any maintenance of the trust? Is there any maintenance involved in the trust, or once you set up a trust, that's it? How does the trust,
the trust is like a document. It exists, and it only controls what's been what transferred to it. So for example, you could set up a trust now, 3 years from now, you could buy a house. As long as when you take ownership of that house, the deed is in the name of the trust and not your name, then the trust will own it 3 years from now. You can set up a business 5 years from now and put the membership or ownership interest in the corporation into the trust. So it exists. I have clients that have trust for many, many, many years. The main thing is that if something changes, right, you have another child, or you listed everything for children when they were minors and now they're adults and you want to modify it, we recommend every 3 years to review it, make sure nothing's changed. So a lot of the clients that come to me for trust changes, they did everything when their children were minors. Now their children are adults. It's been 15 years. They want to modify it a little bit, so things change. I also think in some ways estate planning is like a paradigm shift, right? Like, so once you actually do it, you start thinking about it more and more, and you kind of come up with other ideas. And so, yeah, it does have to be modified, but otherwise it exists. It's like frozen in time. Whatever's there is there. You don't have to do anything for maintenance.
Okay, that's great.
Yeah.
And so like we have some comments about Bobby Brown. Wow. His Bobby got everything. Oh, from Whitney Houston, Bobby got everything that we really need. So important that we as women, get ourselves together and organize and plan. I'm definitely going to be giving you a call. And even as an attorney, it's really good to have people who specialize. I have a general knowledge, right? But it's really important, especially if you have more complicated assets. I think it's really important to get to get somebody who specializes in this area of law. So thank you so much, Leslie. We have a third part in next month. We're looking forward.
Yes.
What is the title for next month?
That one's for retirees. So it might not necessarily be our viewers, but maybe you want to think about helping your parents, right? Because ultimately, I say a trust is a gift that you give your family because you take care of everything during your lifetime. It's so much easier to deal with it. So you might have to help your parents help you because otherwise you're going to be left with that mess if they didn't take care of it for you. So this would be an opportunity to learn about, how did we help our parents, or if you know anybody who's retiring or thinking about retiring, what to think about. It's basically, similar to what I've talked about, except there's different options for trusts in case you want to apply for Medicaid. So we're going to get into that kind of stuff.
Okay. Well, thank you so much for being with us. And we look forward to having you all next week. We're going to be having a workshop Wednesday. Stephanie and I will be coming to you because we're going to be sharing about Session Consulting, talking about our app, talking about how you can get your business on our panel. If you want to be able to be one of the experts that help people who need specialized help in setting up the business, whether it's accounting and legal or book, what else? Marketing. We're trying to set that up so that we can have people. So if you are anyone who's a business owner that would like to be on that panel of specialized experts, that panel of experts, please do contact us. And that panel is going to also, as part of signing up to be part of the panel, you'll also be able to be part of the app, the app marketplace that we have. So we're gonna, a lot of things are happening. We have so much information. So we want to see you all next week so that you can have your questions answered and you can find out how you can be part of our panel, how you can be part of our network of sestras who have their businesses, so that we can get this thing going, get our international, our state to state, get this network fired up and ready to go, because we're all about networking. We're all about promoting our sisters' business and supporting each other. So thank you, everyone, and good night.
Thank you. Thank you for having me in it.